Welcome to the Neighborhood Law Center. I'm your host, Melvin Burris, and our guest today is the Honorable Arlene Gordon-Oliver.
How are you, Mel?
I'm doing fine.
Thank you very much for inviting me
Well,
to the
it's always
program.
great to have you back again.
Yes.
Today we're going to be talking about bankruptcy, the update in bankruptcy, but also how it affects and how it can help you with the housing crisis. But before we do that, uh, Honorable, would you please tell the audience a little about yourself?
Okay, thank you, Mel. I am a sitting judge in the town of Greenberg. When I'm not on the bench, however, I am a bankruptcy attorney, a bankruptcy litigator, and I've also been appointed as a Chapter 7 panel trustee. I was appointed last year, August 2011. As a trustee, I oversee the marshaling, liquidation, and distribution of debtors' assets to creditors.
Mm-hmm.
As a bankruptcy litigator with a private practice, I also have my own private clients, and I represent clients in Chapter 7s, Chapter 13s, and Chapter 11s. So I wear a couple of different hats. My life is very busy, but I love it all.
Well, with your clients, you give them a great insight into the whole process of bankruptcy and what they need to do, which I guess is a plus for them.
Well, absolutely. As a Chapter 7 panel trustee appointed last year, I have the advantage of being on the other side. If you are a debtor and you file for Chapter 7, you would come before me, and I would be the individual who would look at your bankruptcy petition, see what assets you have, decide whether or not I'm going to liquidate your assets to pay creditors. So I come into the arena with the expertise of sitting on both ends of the table.
With a bag full of tools.
With my bag full of tools.
That's good.
Well earned over 20 years of experience in the bankruptcy world.
Okay, so let's get started here. For our audience, what is bankruptcy?
Well, there are different types of bankruptcies, first of all. So there's not one type of bankruptcy that fits all fact patterns. There is a Chapter 7 bankruptcy, which is a bankruptcy where debtors seek to get a total discharge of all their dischargeable debts. There's a Chapter 13 bankruptcy where individuals try to get an arrangement to pay out their creditors anywhere from 3 to 5 years, a payment arrangement, normally on mortgage arrears. Then there's a Chapter 11 that's normally used by businesses or individuals who have high debt. And when I say high debt, your debt has to be over $1.3 million approximately.
Okay.
And that's normally $1 million in secured debt and $300,000 approximately in unsecured debt. So if your debt's over that amount and you're looking to file for bankruptcy, you won't be able to file a Chapter 13. And when I say bankruptcy, a reorganization. So the reorganization is a Chapter 13 or Chapter 11 with the debt limits. That will put you into a Chapter 11 if you don't qualify for Chapter 13.
Okay. So if I do a Chapter 7 and all my debts are discharged, debts that are not exempt anyways, are discharged, then why would I do a Chapter 13?
Well, here is
why would you advise your clients to do a Chapter 13?
Okay. First of all, depending on what your reasons are for filing for bankruptcy, meaning if you are behind on your mortgage payments and you need some time to catch up with those mortgage payments, and you definitely want to file a Chapter 13 because that will give you the opportunity to spread out your mortgage arrears between a 3 to a 5 year period or anything in between that time period. So you get an opportunity to pay out your mortgage arrears over a period of time. So you definitely want to file a Chapter 13 if it is that you need an arrangement to pay out your mortgage arrears. You do have to keep current on your mortgage payments going forward, but you get an opportunity to pay out your mortgage arrears. Chapter 7, if you're behind on your mortgage payments and you have equity in your property, over and above $150,000, because that's the new exemption in New York for most people filing in New York, you have a $150,000 exemption in your homestead. So if you're behind and you have more than $150,000 of equity in your home, do not file a Chapter 7, you'll lose your property. If you are not behind on your mortgage payments and you have no more than $150,000 of equity in your house and you have debt, credit card debt that you want to get a discharge of, meaning you can't afford to pay it and you want to have a fresh start, then you file a Chapter 7. The Chapter 7 will discharge all your dischargeable debts. There's some debts that are non-dischargeable, and those are normally alimonies, child support, student loans, and some tax that is not dischargeable.
Okay. So if I have up to $150,000, then I do want to file for bankruptcy.
Right. You if you qualify
If I qualify.
for
But-
Chapter 7
But if I have like $500,000
in equity.
in equity,
No.
No.
As a Chapter 7 trustee, if you came before me, I would seek to sell that property.
and pay all
I'd
your
pay off your secured
Credits.
creditor if there is one. I'd give you your $150,000, and I would distribute the rest of the equity to the creditor. So you definitely
Okay.
don't want to file a Chapter 7 if you have more than $150,000 in equity
Okay.
in your house.
for-
That's just for one individual, by the way,
Right.
because if there are two owners of the house,
Mhm.
it's $150,000 in equity each.
each.
So if it's a husband and wife who files, it's $300,000.
Okay. Next question I was going to say, if I file for bankruptcy, do my wife have to or my spouse have to file?
No, not necessarily.
Mhm.
And oftentimes you will find that some people will file jointly, but depending on what it is why you're filing, for instance, if it's to cure the arrears on your home, although the husband and wife are joint owners and are both on the mortgage, one person filing can take care of the problem. Two don't necessarily have to file. If, however, they're credit card debt, and you want to also get a relief from the credit card debt, and it's credit card debt in both the husband and wife's names, then you definitely want to have both parties file. In a
Okay.
Chapter 7, you can also have the husband file and not the wife. It all depends on the type of debt and who's named the debts.
Okay. Well, that's good information because I think many of us think that if I have to file, then my wife has to file. But you're telling us that's not the case.
That's not the case.
Okay.
Not necessarily.
Now, you mentioned earlier about loan modifications and how that relates to bankruptcy.
Okay, yes, we were talking earlier before the program, and I told you that one of the things that's great about the bankruptcy process in New York, especially in the Southern District, also in the Eastern District. The Eastern District is Brooklyn and Long Island and Staten Island. The Southern District is Manhattan, the Bronx, White Plains. White Plains is where I sit as a bankruptcy trustee, by the way.
Mm-hmm.
In the Southern District, there is a process in the bankruptcy court that's called loss mitigation. All it is, it's modification of your mortgage in the bankruptcy court, overseen by the bankruptcy judge.
Okay, why would I do it in a bankruptcy? Why don't I just call up a bank and say, hey, I want to do a loan modification. I heard the federal government is doing this loan modification. Can I do that?
Okay, you could, but if you want to be totally frustrated by not first getting a live person on the phone and being transferred from one department to the other and waiting 2 years to finally get a response, and normally that response will be, sorry, we can't process your application because we don't have the correct paperwork, or we're denying it because of whatever arbitrary reason, then you can definitely try to do it on your own.
Mm-hmm.
I suggest, however, that the bankruptcy court is a wonderful medium to do a loan modification, loss mitigation it's called, because you have a bankruptcy judge who presides over the process. The process really entails you getting the debtor getting the documents to the bank responding. Time frames are set up by the bankruptcy process.
Back directly to the court.
To the court,
Mm-hmm.
affidavits are filed saying what's needed. Affidavits are filed saying what's supplied, and if one party or the other does not comply, then the bankruptcy judge will have the authority and does have the authority to find out why the bank especially has not complied with responding to the debtor's request for modification. So that means if the bank is tardy on processing your papers, they have to respond back to the court in a hearing why it's taking so long. If the bank has denied the application, they also have to tell you in bankruptcy court why they've denied it. So there's no longer this open-ended waiting on a bank. This process is set up so that the process can be streamlined. People can know whether or not they qualify, or not qualified, but with some rationale and with some explanations and some time frame set. So
Now
you're
this
no
is
longer left at the mercy of the bank.
okay. Now this is chapter 13, though.
You can also do loan modification or loss mitigation in chapter 7.
7 also.
Yes, you can do
Okay.
it in both chapters.
It's a great tool.
It is a very good tool, and I'm hoping that for the viewers who are having trouble with their mortgages, that they would really take it into consideration. I know that some bankruptcy attorneys who have appeared before me when I'm sitting as a Chapter 7 trustee, I've often asked them why haven't they tried to do loss mitigation for their clients, because I think their client would qualify. And some, unfortunately, hadn't realized that this process was there. So I just want to caution the viewers that if you are going to seek help from a bankruptcy attorney, make sure the bankruptcy attorney is qualified and they know what they're doing, because that's your one shot to get everything sorted out, one shot in, 10 years. So you really want to make sure it's a good one shot that you take.
Or they can call you.
Well, that'd be great.
Which is on our screen.
Yes, they can also call me, and because I have been doing this for at least 20 years and I know the ins and outs, then I'll be able to properly advise you.
Another question I have, we talked about chapter 11 being for businesses. What about a self-employed person?
Okay, and there is the individual Chapter 11 cases. And when I say an individual Chapter 11 cases, it means an individual who sometimes finds it necessary to file for bankruptcy. They don't qualify for Chapter 13 because their debt is over the limit, and therefore they have to file a Chapter 11.
Okay, so
yes.
Self-employed can file a Chapter 11.
Self-employed can file Chapter 13 or an 11, but it depends on the debt limit. That's the issue.
Okay. Okay, now, many questions my viewers ask is, what about credit again? If I file, for example, Chapter 7, and they discharge all my credit cards, will I ever be able to get credit again?
Absolutely. And what I find is that credit is easily obtainable, or I should say easier to obtain, if you have gotten a discharge of your dischargeable debts, as opposed to not having dealt with the debt. If your credit report indicates that you haven't paid your credit card debt for a while, you're not ever going to get credit. If you file a Chapter 7 and you get a discharge of your debt, one, the creditor who wants to offer you credit again knows that you no longer have the burdensome debt that you had before, and if you're employed, then they know that you have income to support a credit card or whatever it is that you'd like to get. And frankly speaking, you're a good candidate because you won't be able to file bankruptcy for several more years. Therefore, their debt is safe and they know they're going to get paid. So you're a perfect candidate if you file a Chapter 7.
Okay.
Chapter 13, though, have to be careful. You only get an opportunity to incur additional debt or new debt after the bankruptcy process is over in the Chapter 13.
And so that's a time frame.
And that's a time frame between 3 to 5 years of a repayment underneath whatever Chapter 13 plan that you make.
Okay.
You have to complete that plan, be out of chapter, then you can incur debt.
So now let me get this straight now. You were saying before that bankruptcy stays on your credit report for 10 years?
That's correct.
And now what is the 7 years? You can't file bankruptcy
That's
for
right.
another 7 years. Okay.
Well, no, it's just a time frame that you have to look at to be able to file for bankruptcy again.
In 7 years.
Actually, it's longer than that now.
Oh, it is?
Yes, they increased it to, I think, 9 years. I have to check.
9 years.
Yes, before
Okay.
It used to be 7.
Right. Okay.
Yeah.
But it stays on your report for 10 years.
It stays there for 10 years.
Okay. And we already talked about the fact that students' loans now are a big debt of individuals at this
That's right.
stage.
Young people. They're burdened by student
And old
loans.
people, too.
I have to tell you, in our day, we thought we were burdened by student loan debt, but there young people coming out of college, law school, $200,000 worth of student loan debt. That's almost a mortgage, or sometimes it is a mortgage if you're talking about a condo or co-op. And, it's interesting that the dearth of jobs has made it even worse for these young people. So they're laden with debt and they can't find a job and they can't get a discharge of their student loan currently because there are certain criteria that you have to meet in order to get a discharge of your student loans, and one of them is that the degree that you got is so you can't use it, or you're disabled, or it's just really in extreme circumstances that you won't be able to get a discharge of your student loans. There's a move now to petition Congress to have that section of the bankruptcy code changed. So we'll see what happens.
So our next bubble may be student loans coming out.
The bubble is here.
The bubble is here.
Yes, absolutely.
Okay. People. The big reason people go into bankruptcy is because creditors keeps calling. Once you file for bankruptcy, how do you get creditors to stop calling?
Well, I'll tell you, if you file for bankruptcy and you notice your creditors that you filed, if they violate the automatic stay, whenever a bankruptcy petition is filed, there is something called an automatic stay pursuant to Section 362 of the Bankruptcy Code, where all action against the debtor is automatically stayed. Once you got notice, or even if you didn't get notice, everything stayed. And if a creditor violates the terms of that automatic stay, then they're subject to damages in bankruptcy court. So, and creditors know that.
And so if they keep calling, you can send them, first you give them notice.
Well, the bankruptcy court sends notice.
Oh, the bankruptcy court.
So they're on the list of creditors that's filed with the bankruptcy court. The bankruptcy court uploads that list and sends a letter out to all creditors.
Let's talk back and say, what is the process once bankruptcy gets started here? What happens?
Well, in order to start a process of bankruptcy, you have to file first the bankruptcy petition, whether it's a 713 or an 11. That bankruptcy petition has a list of creditors on it. In addition to other things, it has a list of your assets and, your financial affairs, whatever, your financial affairs contain, including how much money you've made for the last 2 years. I mean, it really goes into detail. A list of creditors is filed with the bankruptcy petition, which is uploaded by the bankruptcy clerk. A notice to all creditors are sent, not to your job. A lot of people ask whether or not your employer needs to know. No, your employer doesn't need to know. So your employer is never on the bankruptcy petition. They don't get notice. It's only creditors. Creditors get notice, and there is also a 341A hearing. That's a hearing in the bankruptcy court, which I preside over when I'm a Chapter 7 trustee, that says, come down to the bankruptcy court. We need to interview you. And creditors, you're welcome to appear also, and you can ask questions if you need to. Oftentimes, creditors don't come unless they have an issue with your bankruptcy filing. For instance, if they believe that you've committed some fraud or some other issues that they have with the filing, then they will come down. But most often, creditors, the credit card companies, they don't come down. So that hearing is held in the bankruptcy court with the Chapter 7, 13, or from the U.S. Trustee's Office in an 11. And after that interview is conducted, then the case is prosecuted by the bankruptcy court, meaning that whatever paperwork has to be submitted to say their assets, no assets, this person gets a discharge, this one doesn't, the Chapter 13 plan is confirmable, not confirmable. Those are the things that happen after the bankruptcy filing.
And you as the attorney walk your client through this whole process.
Absolutely. There's some individuals who try to do bankruptcy on their own. I would advise against it because there are certain pitfalls. There are deadlines that have to be met, and if you don't meet those deadlines or requirements, then your case can be dismissed. So you would have wasted your time and effort prosecuting a Chapter 7 or 13 case, and you don't get the relief that you need because you've made a mistake.
Okay. A lot of times people will say, well, do I have to put my car? I need my car for work. Do I need to put my car, the payments that I make to my car, on that petition you're referring to?
Okay, and let me just say that one of the great things that Governor Pasterson did before he left office is that he increased the exemptions in New York State, not just for the homestead, the $150,000 exemption that we talked about, but he also increased the exemption for an automobile. He increased the cash exemption, meaning that you were allowed to keep some cash if you filed for bankruptcy. Okay, he also increased the exemptions for your household goods and various other exemptions. So he really did debtors a great service before he left office. So depending on the equity in the vehicle, meaning if you're driving a very expensive vehicle and there is no loan against it, and this vehicle is worth $50,000, if you sell it, just in its condition, then I would tell you that the exemption that you get is no more than, sometimes there are different types of exemptions. There's something called a wild card, but I'll tell you that your exemption is not going to be no more than $8,000, depending on the exemption and the federal bankruptcy rule that you use. So therefore, I would love to have that case as a Chapter 7 trustee, because I'd liquidate that vehicle and that money would go towards paying your creditors.
Okay, so what if I don't put my car like that down there?
Well, no, you're obligated to put all your assets, all your liabilities, all everything.
That's what you referred to as fraud before.
That's correct. Now, when you have a vehicle that's a reasonable value, or you have a lien against the vehicle because you have a note, or it's a lease, then that vehicle more than likely will be exempt from the reach of your creditors or the trustee.
Do you have to contact the dealer that you may have this car with?
The dealer is on the list of creditors.
Okay.
So the dealer gets notified. But if you intend to keep the car, then you can always continue to pay the debt and reaffirm the debt in the bankruptcy. Meaning, tell the dealer, I'm going to continue to pay you. I want to keep my car. Oftentimes, that arrangement is fine with the bankruptcy process. The only time it's not fine is if the bankruptcy judge thinks that you can't afford this vehicle. And then there's an issue with respect to how do you intend to keep it, how do you intend to pay for it. Okay.
Another question that keeps coming up, because housing or your home is very important. And some questions the viewers have asked us is, can I sell or refinance my home?
If you're in a bankruptcy process, you cannot refinance. If you're in a process, you have to wait until the process is completed before you try to get a new loan. No creditor is going to lend you any monies while you're still in the process. So the question is, if after you've completed the process, can you refinance or sell? You're free to do whatever you want to do after the process is completed. So now in a Chapter 7, the process is short. In a Chapter 13, the process is a little bit longer. If it is that in a Chapter 13, where you've made an arrangement to pay out the arrears and you find yourself stuck and you don't have enough income to pay the arrears out, and you decide to sell it, then you make a motion to the bankruptcy court.
Okay, well, there's a lot of information that we need to talk to you about before you decide to do that. But another thing is, people keep asking, can a bankruptcy stop a foreclosure?
Absolutely.
Okay.
Once the bankruptcy petition is filed, before that hammer falls, the foreclosure is stayed.
But you mentioned before that if you're in foreclosure, it means that you are in arrears.
That's right. That's right. So you're talking about a foreclosure sale and the foreclosure action. Once you file, that action is automatically stayed. Now, I have to caution viewers that if that hammer went down at a foreclosure auction and you have not yet filed your petition, then you don't get an opportunity to put the horse back in the barn, put everything together.
So once they've stood on the courthouse steps,
it's over.
And paid, then it's over.
Yes, if you filed 1 minute before they did it, then they can't go forward, even if they did not get notice from you at the courthouse. So oftentimes there's an issue as what time did the hammer fall, what time was the bankruptcy petition filed.
So can you give our viewers a kind of overview what you think they should consider before they think about bankruptcy, or they should do bankruptcy or not do bankruptcy? What are parameters?
Well, every case is fact specific.
Right.
But what I do know
generally
what I do know is that a lot of people are facing right now heavy credit card debt. They should consider sitting down with a bankruptcy attorney, going over the debt and trying to figure out whether or not they qualify. One of the things that some people might not qualify for Chapter 7 is because there is now a means test that people have to go through. It's an arbitrary test. It's done pretty much a computerized test where you plug in the income that the individual has for the last 6 months, and you plug in the allowed expenses for the family during that period, and the test will come out whether or not there's a presumption of abuse, meaning that is there enough money left over at the end of the month to pay creditors at least something? And that's the test that's set up. But there are you know,
How does unemployment income affect filing or not filing for a bankruptcy?
well, if you're on an unemployment income, I'm assuming that that income is much less than what you used to
Hmm.
earn, therefore you're falling behind most often on your credit card debt. And if you're getting unemployment, you can file for bankruptcy once your unemployment doesn't go over the median income on the means test, and oftentimes it doesn't.
Okay.
And I tell people, if you're going to file, you want to file when you have no money. Don't wait until you get a new job, money starts rolling in, and you still have the credit card debt, because at that point, you might just have gone over the median income and you no longer can file for bankruptcy
Okay.
and get a discharge.
I guess I know the answer to this already, but I'm going to ask it anyways. Does a bankruptcy stop contracts and other judgments?
Okay, I'm not sure when you say contracts. Judgments, if the judgment's already filed,
Hmm.
then the bankruptcy does
That's
not
just, that's just like
necessarily.
standing on the courthouse door.
Well,
It's
yes,
done.
but there is a time frame because the judgment could be considered preference, and
Hmm.
this is now getting into deep legal
Okay.
bankruptcy stuff. The judgment
Okay.
could be
We
considered a
don't
preference,
we don't
and
want to
then
do
your
that.
attorney, your bankruptcy attorney, will petition the court to
Mm.
avoid that judgment because it's a preference.
Okay. You mentioned before about you don't have to notify your um, employer. But what if you have a garnishment, a wage garnishment
Okay.
going?
All right.
How's that affected?
And then you definitely want to notify your employer that you have filed for bankruptcy, because once you file for bankruptcy, then that wage garnishment should be stayed, should no longer be going through your paycheck, and
Mhm.
therefore your employer, who's the one who actually got notice of the wage garnishment, who's authorized the payroll department to take these funds out, has to be aware of the bankruptcy filing so that those monies can start flowing back to you.
Okay. So we've learned quite a bit. I mean, this is like bankruptcy 101 that I'm ready to go
Well, I
out.
don't think you're ready to file anything on behalf
No,
of
no,
anyone.
no,
I
no.
think
Not without the assistance of an attorney.
that's
And that's
correct.
the whole thing. People always ask the question, do I need an attorney when I'm trying to do this bankruptcy or any kind of legal transaction like this?
I would tell you, yes, there are pitfalls. As I said before, there are time frames that if you blow them, you don't get them back. There are also motions that could be made. For instance, if you have a second mortgage and
Hmm.
it is above the value of the property is less than the second mortgage and the first mortgage combined, then you
Okay.
can lien strip, meaning that you can get rid of that second mortgage as a secured claim.
Okay, our time is up and it was very informative. Well, thank you for coming in, Counselor,
Thank you very much.
Trustee. And I want to say again, would you leave your number with our audience?
Yes, my number is 914-683-9750. And
Okay.
I'm located at 199 Main Street in White Plains, New York.
Okay. And I've been your host, Melvin Burris. Our guest has been the Honorable Arlene Gordon-Oliver, and this has been the Neighborhood Law Center. I want to remind you to go to our website, neighborhoodlawcenter.com, to see other programs that we've done. Okay, until next week, I like to just leave this caution. If you're thinking about bankruptcy because of the housing crisis, please contact a bankruptcy attorney
That's
that's
correct.
knowledgeable like Judge Oliver here. Until next week, peace and God bless.
Thank you, Mel.